Yes, please.
He's here.
The court had to pay on an entire for no reason.
On the record, in the matter of the people of the state of Michigan versus Brandon Craigville, 23-03160. Have your appearance.
Judge, I'm sorry. Did you call the Probable case?
That's correct.
Okay, I wasn't sure. It was hard to hear that. For the record, Judge, my name is Mark Burke. My P number is 54935. I'm with the Attorney General's office appearing for the people.
Thank you. And then Mr. Crable is present today inside the courtroom. Whoever's on the Motorola is causing feedback. That's why I muted you. Are you driving, sir?
I'm in the car. I'm from an interview.
Okay, I gotta mute you because you're causing feedback, okay?
Yes, ma'am.
Thank you. Okay, today was the date and the time that was set for a probable cause conference. Mr. Crable's present in the courtroom without a counsel, correct?
Yes.
Did you request court-appointed counsel?
I didn't qualify.
Okay, you were denied because you're not indigent and meaning you make too much money.
Yes.
Okay, and so you want to hire your own attorney, or how do you want to proceed?
No, I have actually gone to law school. I'll do self-represent.
You're an attorney?
Not until this is settled.
Oh, okay, so you've gone to law school, you passed the bar and your bar license is tied up to this case is what you're saying?
Yeah.
Gotcha. Okay, and so you are willing to waive your right to counsel to proceed on this matter? Okay, and so how do you want to proceed? This matter is scheduled for a preliminary examination November 17th at 1:30. Are we going to continue to examine at this time, or are we negotiating how we're going to resolve this still?
So I've been in contact with someone with the AG's office and told them that the balance has been paid. There's some delay in the actual reflection of the payment amount from the bond amount that was paid was 25%. And the rest has been paid. It's waiting for that bond amount to show from the court that was paid to Union County.
Okay, so you're in position that you paid this in full?
Yes.
Okay, counsel, is it true that we're just waiting for some paperwork to catch up so that your office can reflect payment in full?
Judge, a few things. First of all, I do note the defendant has made a lot of very, very strong payments recently. The balance that I show as of Tuesday, November 7th is $5,464.89. The defendant did post a bond of, it looks like he posted a bond of $34.31. I assume he posted that because he's in court. He may have made other payments. The last three payments I show are $4,000 on November 3rd, another $4,500 on November 3rd, and then $1,700 on October 31st. So there may be some payments or a payment that's subsequent to that just hasn't reflected on the Michigan Child Support Enforcement System report that I show. That being the case, as far as today's is concerned, it's up to the defendant what he wants to do as far as continuing the prelim exam. If he does, any kind of offer might be off the table. So I just want to make sure he's aware of that. If the defendant wants to take my number, we can talk and we can figure this out. Probably the best approach, in my opinion, would be to reschedule a PCC since the defendant is making strong payments. Maybe reschedule a PCC so that we don't have to subpoena witnesses for a prelim exam, and then we can work out some kind of a resolution.
Okay, you were gonna say something, sir. You said there's two other payments that
Yeah,
are
there's two
pending?
other payments, but we could discuss
Oh,
that.
okay. Do you believe there's two other payments outside of the ones that you just mentioned on the record? So maybe those are still pending? I mean, maybe that will resolve this matter. I do see where you posted a bond of 3431 in this particular matter. So we are scheduled for an exam next week. We'll treat that date as a probable cause conference.
Okay, that'd be great, Judge. What's the date of that?
It's November 17th at 1:30.
Okay, very well.
Okay, do you have any questions today, sir? Can you say that so the record picks up?
No, I do.
Okay, and so, let's see. If you have the capability of appearing with Zoom, you don't have to appear in person, it's up to you. If you want to appear via Zoom or in person, you just need to make sure your video works and that you're in a position appropriate for court, okay? Okay, so we'll
Judge,
see you next week.
with
Yes.
the prelim exam next week being rescheduled to a PCC, would the defendant have to waive the 21-day rule at all? I think he might
Now,
have to.
I'm just treating next week as a PCC, and then I'll address the 21 days if necessary.
Okay.
By next week, we
Okay.
may have a nollie for all I know, so I won't
Okay,
address that today. Okay,
Okay, very well.
no problems. Any additional matters? You have questions, sir?
No.
Okay, you're all set then for today.
Judge,
Thank you.
is it possible to give the defendant my cell phone number so he can give me a call? We can talk about a possible resolution.
Okay. You want the defendant's number, or you want him to have your number?
No, he can have my number. That's fine.
Okay, can you put it in the chat feature?
Absolutely. I'll do that right now, Judge.
Thank you. You have a
Thank
seat,
you.
we'll get you his number.
Thank you.
No problem. Okay, and then, let's see. Who's ready with whom? Well, okay. On the record in the matter of the people of the state of Michigan versus Timothy Lockoff, file number 23-03177, council appearance.
Jeff Broadouts on behalf of the people, Your Honor.
Good afternoon, Your Honor. Dustin Kuntz for Timothy Lawcock, both of us appearing by Zoom.
Okay, Mr. Lockoff, you can hear us, correct?
Yes, ma'am.
Very good. Today's date set for probable cause conference. I have one count of larceny by conversion, $20,000 or more. This matter is scheduled for preliminary examination November 17th at 1:30. Are we proceeding to exam?
At this time, Your Honor, after conversations with defense counsel, I believe the parties would ask that this be set out a little bit for a second probable cause conference as negotiations are continuing.
Mr. Cruz?
That's right, Your Honor. And just to give the court a little more context, we think there's a pretty strong likelihood that there could be a proffer here that would, I guess, affect the parties' posture on the case. So we just need a little more time to be able to produce the documentation, set up that proffer with the appropriate law enforcement agency, I think LPD in this case, and from there, I think we'll know how we need to proceed in district court.
Okay, so how much time are you looking for?
I would leave that to Mr. Kuntz, Your Honor, as he's the one who needs to get the documentation from his client. I know we talked about possibly like right after the holidays, first week of January, but I would leave it to him to say for certain how much time he thinks he will need for that.
Your Honor, I guess I'm always optimistic, but I think even a month would probably be sufficient if we can get everyone in line.
Have you discussed with your client his right to have the exam within 21 days of his arraignment?
I have, Your Honor.
Okay, Mr. Lockoff, you understand that you have the right to have your preliminary examination within 21 days of your date of arraignment?
Yes, ma'am, I do.
Okay, you were arraigned on this matter on November 2nd, and so your preliminary examination is currently scheduled for November 17th. Are you willing to waive the 21-day timeline in this matter so that we can reset this out 30 days?
Yes, ma'am.
Anybody threatening you to make that waiver?
No, ma'am.
Okay. December 15th at 10 a.m. Any
Works for me,
additional
Your
matters
Honor.
for today's record?
Nothing from the people, Your Honor.
Just briefly, Your Honor, I would ask the court to amend one of my client's bond conditions, and I did let Mr. Brodowitz know this this request was coming ahead of time. Magistrate Milmore, as I think kind of a pretty standard condition in this court, prohibited possession of any firearms for my client. I understand he is charged with a felony here, and that's pretty standard around here. He is an avid, passionate hunter, and we are 6 days out from opening day. I think I don't know if it's his property, but he has a yearly tradition where he goes up north with some friends and family for deer camp. So we would ask for maybe a slight amendment to his bond conditions to allow him to possess a rifle solely for the purpose of hunting. And just to add a little bit more to that, Your Honor, my client has very limited criminal history. He does have one assaultive crime from 30 plus years ago, but nothing since then. This is an allegation not involving endangerment of any person. Frankly, it's one I think that my client's innocent of, but not here to litigate that fact. I just think that the court and the people can rest assured that he's not going to pose a danger to society by being allowed to hunt. Thank you.
Prosecution want to respond?
People would just oppose any modification to bond, Your Honor.
Defendant is being charged with one count of larceny by conversion. It's a felony with a maximum penalty of 10 years and/or $15,000 in fines, or 3 times the value of the property stolen, whichever is greater. I don't have his prior criminal history before me. Magistrate Milmore, however, did have the defendant's criminal history before her when she made the determination as it relates to the bond conditions, and it's pretty standard, actually, not just pretty standard. It goes without saying, if you're charged with a felony, at least in Ingham County, the bond conditions will include you are not to possess a firearm or any other dangerous weapon. So the request for a bond modification is denied. Any additional matters for today's record?
Nothing from the people.
No, thank you, Your Honor.
You're all set. Okay, we ready for, let's see. Sir, whoever was on the Motorola, I never got your name. What is your name?
The Quandrick Jones.
Okay, Ms. Robinson, that's yours. You ready?
Yes, I'll need a breakout room.
Okay, your attorney needs to speak to you. Give me just a moment.
Make sure I'm pretty bad about no, so be better than me. I know how. Yeah, I know.
Is person here supposed to be in person?
Sure.
Okay, where's this attorney?
Starts with him about PCC from Wayne County.
Okay. Sounds good. And then,
It's just pieces of.
Savon.
Yeah, I ran into David Hayes down in the hallway. We spoke. She said she just wanted to leave it set for exam.
Who else did she say that to?
Just myself, Your Honor. She's right across the hall, I believe.
Oh, you heard her say it?
I think she probably.
And then you said starts was weird? Okay. Then, that was Zavala. I'm sorry?
You good on Zoom?
Correct.
Oh.
And then Olson was continued. And then that's Mr. Myers. Are you ready?
Yes, Your Honor.
Jaquay Jones was continued. Okay, on the record in the matter of the people of the state of Michigan versus Maurice Antoine Myers, file number 23-02984. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Mr.
And
Myers,
Assistant Public Defender Sarah Donnelly on behalf of the defendant Maurice Myers, who is present and coming up to stand on my right.
okay, today's the date that was set for a preliminary examination, actually was set for a plea. What's the offer, Mr. Brodowitz?
I believe on this case, Your Honor, the offer was for Mr. Myers to plead to an added count 2 and count 3 of assault or assault and battery. The people would then dismiss count 1, Your Honor.
Added count 2 and count 3?
Yes, would have been 2 counts of assault or assault and battery and dismiss count 1.
Okay. Okay, counsel, did your client want to accept that?
Your Honor, at this time, I've learned information that makes me believe that Mr. Myers would be eligible for mental health court. And I think if he is eligible, that it would probably be the best place for him if he's going to do a term of probation. So at this time, I'd be asking permission from the court and the prosecutor's office to seek that screening. It's my understanding Mr. Brodowitz would like to have a discussion with his office before agreeing.
Yes, Your Honor. Ms. Donnelly did make me aware of that, and I have informed her I would need to speak with my office about any potential modification to the offer before agreeing for Mr. Myers to attend mental health.
Okay, let's see. We've already waived the 21 days, so we don't need to address that. We'll set this out.
Your Honor, I don't, just wanted to adjourn the plea. Just keep setting it as a plea.
That's fine. November 16th
At 8:30.
at 8:30 in the morning.
Oh, November 6th. Oh, yes, so that we can find out.
Correct. And if you find out that he is going to be screened, you can just email my staff. We'll reset it to give him time for the screening versus coming back and forth.
And you, Your Honor, have no objection to being screened for mental health court?
I have no objection.
What time is that?
8:30 on the 16th. Do you have any questions today, Mr. Myers? Okay. We'll get you a notice to appear and you'll be all set for today. Any additional matters for the record, counsel?
Nothing from the people, Your Honor.
No for defense.
Okay, thank you. Ms. Robinson, are you ready with your client?
Yeah.
On the record in the matter of the people of the state of Michigan versus DeQuandrick Jones, file number 23-03270, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Karen Robinson, Assistant Public Defender for Mr. Jones.
Okay, Mr. Jones, today's the date set for probable cause conference. I have 1 count of weapons carried concealed, count 2 of weapons firearms possession by felon, count 3 a felony firearm, and then there's a habitual offender 3rd offense notice. And these matters are scheduled for preliminary examination on November 17th at 2 p.m. Are we continuing to exam?
Yes, Your Honor, we're just going to leave this set for next week.
Okay, so we'll continue to exam for next week. Mr. Jones, do you have any questions for the court at this time?
No, ma'am.
Okay, so you're aware you need to appear in person next week?
Yes, ma'am.
Okay, well, good luck to you in your job interview. Any other matters for today's record?
No, Your
Nothing
Honor.
from the people, Your Honor.
You're all set, sir.
Thank you.
You're welcome. Okay, let's see. We're here with, is John Sherman present? No? Oh, he's on Zoom, very good. On the record in the matter, the people of the state of Michigan versus John Sherman, file number 23-03161. Appearance, please.
Yes, good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good afternoon, Your Honor. Stephen A. Freeman, Public Defender, appearing on behalf of Mr. Sherman.
Okay, Mr. Sherman is present via Zoom. Mr. Sherman, can you hear us? If you can, you can just wave your hand. Very good. Okay, today's the date and the time that's set for a probable cause conference. This matter is scheduled for preliminary examination November 17th at 2 p.m. on one count of unlawful imprisonment, one count of assault with intent to do great bodily harm less than murder or by strangulation, one other count of assault with intent to do great bodily harm less than murder or by strangulation, and a domestic violence and habitual offender fourth offense notice. Are we continuing to exam?
Your Honor, there are two issues that need to be addressed. First, my office didn't receive the appearance in this file until this morning from the Public Defender's Office. I don't know where the holdup was along the way. I know discovery went out. I can see confirmation went out around 9 a.m. today, but there hasn't been the ability to have any other significant conversation on this because I didn't know Mr. Freeman was representing the defendant until about an hour ago. Now, that's its own issue. Secondly, in reviewing this case yesterday for the preliminary examination today, I came across a file from 2021 that I had signed. I had signed that file in 2021, and that's for lawful imprisonment, strangulation, during the crime report, largely from the person, DV, A, and B, for the same victim, even at the same address. That occurred on October 4th, 2021. I signed it about a month later in November, but apparently that was never brought over to be sworn to. I have re-signed it as of yesterday, so it should be brought over hopefully at the beginning of next week. Again, it's one of those things that we're just not able to catch it until sometimes this brings it to our attention. Thankfully, there have been significantly less, but this was still a holdover from early COVID when that was still an ongoing problem. As a result of that, Your Honor, I think an adjournment of the PCC and the PE would be appropriate, so that way these can be discussed together, and so the defense can have discovery from each of these incidents together. And there is significant discovery in this case, as there was medical reports that were gained from the hospital, as the victim did suffer from suspected spinal fractures.
Mr. Freeman.
Thank you very much, Your Honor, and good afternoon again. I had an opportunity to meet with counsel prior to going on the record, and I had been made aware of this, call it the 2021 complaint. It seemed to be well within the statute of limitations, but given the circumstances and the similarity, et cetera, the same complaining witness, I would join counsel in encouraging the court to allow my client to be arraigned on the new complaint, and then perhaps we can set both matters for the same dates at the same time that would please the court. I'm certain it will come to my desk. I can only assume that it will come to the same court. So, okay,
we will. I will first find good cause based on the two reasons presented today. That being that the prosecutor's office did not receive the appearance timely in order to get discovery to you timely for you to even discuss this matter with your client, and then also because there's another case that needs to catch up. So I'll find good cause to go beyond the 21-day timeline so that I can get this reset for a new PCC and new exam, because I don't know where this other file is. You said it's already been sent to.
I had signed off on it back in 2021. It should have been brought up, we sworn to. I think it did. We had that voided new complaint drawn up yesterday once we realized this happened. I signed off on it yesterday, sent it back to the warrant division for them to make up the swear to packet to be taken to court. That does not normally take any kind of lengthy period of time. So it should be by at least this time next week. I'm also going to follow up.
We would hope. But sometimes it does take a long time for things to work its way back to the judge and then into the system. So I'm going to set this for another PCC so we can catch up with the other one, and then I'll hold off on setting the exam until I know what the exam date on the other one is, okay?
The people have no problem with that, Your Honor.
We have a November 17th exam date. I'll just treat that as another PCC for now.
Thank you, Your Honor.
17th, you said?
That's correct.
Thank you very much.
Okay, any additional matters for today's record?
Not from the people, Your Honor.
Nor from the defense, Your Honor. Thank you.
Thank you. Mr. Sherman, did you have a question for the court at all? If you do, you need to unmute yourself. You're muted.
Hello?
Yes.
Yeah, they said the date was 2021. I was charged with a domestic and it was dismissed.
I have no
I guess
idea
it-
what happened. I have no idea what happened in 2021. I'm not privy to that. You should probably have a discussion with your attorney off the record so he can investigate that for you, okay?
All right.
You have any questions for the court?
No.
Okay, you're all set. We'll see you next week at 2 p.m.
On the 17th?
That's correct.
All right. Thank you.
Thank you.
Mr. Freeman? So the salary incident that I had charged was from October 2021. There was a misdemeanor domestic, same victim in December of 21. That ended up being, so that's what he was thinking.
Thank you.
No problem.
Nico Wheeler? Are you present?
She's supposed to be in custody, Your Honor.
Is she?
Oh, yeah, she is.
She may also be
Just
down
here.
in Judge Buchanan's.
Where?
Oh, yeah. Are they
She
supposed
is.
to be doing it at
They
the
have,
same
they
time?
have the retail. for-
Yeah,
She's
yeah.
in person though, correct?
What's the name?
Shaniqua Wheeler?
You guys want me to go down check real quick? I have nothing else after
If
this.
you can.
Yeah,
Yeah, because she's not highlighted on my
Well,
document.
Robinson has the.
Yeah, let me go check.
Thank you.
Yeah.
no problem.
And we're supposed to fight over who gets,
Nice.
like in person.
So. Ann-
Shanika Wheeler,
On another
right?
day. Shaniqua Wheeler.
Shanika.
She might be out.
Yeah.
So we need Potter and Wheeler, and then we need Sarts for Harrison.
For Wheeler, Your Honor, though, I just got appointed to that yesterday and I don't have discovery, so I just wanted to leave it on.
Okay, we just want to make sure she's here.
Yeah.
Yeah.
Was there any offer?
I thought I emailed you.
For Wheeler?
Yeah, it's a big long. one.
Yeah, that's
She
for
takes
Monday.
one to retail fraud.
Why do her name sound familiar?
The misdemeanor, because we have her on a misdemeanor A and B.
She was here on Monday, yeah.
Yeah, she was here Monday, I think, from our CJ.
Mhm. No, I think she was in person. Yeah, she's out of ICJ.
If she shows up.
But on the street is she's around the corner. You too. On the record, in the matter of the people of the state of Michigan versus Percy Harrison, file number 22-01722 FY, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good afternoon, Your Honor. Jacob Starks, the fourth assistant public defender here on behalf of Mr. Harrison. Mr. Harrison is present at council table, standing to the right.
How are you, Mr. Harrison? I'm doing well. Okay, today's the date set for plea. I have here an offer. It says that the people are offering for you to plead no contest to an added count 2 of malicious destruction of a building 200 or more, but less than 1,000, with an agreement for restitution on this file and file number 23-00818 FY, and that the people will dismiss count 1 and file count 23-00818. Who is that case before?
That is before, it's out in 55th, Your Honor. I'm not sure. I believe it's before Judge Hillman.
What's the restitution amount?
The restitution amount, we have not received official documentation, but according to the police reports, Your Honor, the restitution amount in this file, I believe, would be about $2,400. And the restitution in the file out in 55th would be about $500.
So the issue inherent in this is we can't enforce after that case is dismissed in collection of restitution on another file. We won't be able to do that. We've had that issue before.
With that, Your Honor, I believe,
Okay.
sorry, with that, Your Honor, I believe we have an agreement for restitution in the amount of $2,900. That would be owed to, I believe it's the city rescue, 2,400 would be owed to the city rescue mission. And then I believe the other one is $500 to, I believe it's the jail.
Okay, and you're gonna get us restitution forms for that?
Yes, Your Honor.
Is there agreement as to that amount of restitution?
Your Honor, I think it'll be sufficient at this time to settle the case. Certainly, Mr. Harrison could request a restitution hearing.
Mr. Harrison, are you agreeing to restitution or did you want a hearing? Okay, and you want to enter a no contest plea today?
Yes, ma'am.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Okay, I do have an advice of rights and plea information sheet. That's your signature.
So far.
Is that your signature down here? You signed this?
Yes, ma'am.
Did you read this before you signed it?
Yes, ma'am.
Do you understand all the rights there?
Yes, ma'am.
Do you have any questions about these rights?
No, ma'am.
Okay, so you have the right in this matter to proceed to a trial, and you have the right to jury trial. You have the right to the presumption of innocence. So that means you are innocent, sir, until proven guilty, and you have the right to require the prosecution to prove your guilt at a trial by proving each element of the charge being brought against you beyond a reasonable doubt. You understand that right, or those rights? You have to say it so the record hears
Yes,
you.
ma'am.
Are you willing to give them all up today in order to enter a no contest plea?
Yes, ma'am.
Okay, so you also have the right to cross-examine any of the witnesses that the prosecution intends to call against you at trial. You have the right to call your own witnesses or present evidence at trial that you believe further defense to the charge being brought against you. You understand those rights as well?
Yes, ma'am.
Anybody threatening you to get you to give up all of these rights?
No, ma'am.
Has there been any promises made to you to get you to want to give up these rights?
No, ma'am.
And you're not on probation or parole,
No,
correct?
ma'am.
Okay, and you understand that a no contest plea in this matter could result in a conviction that you may need to put on a future job application.
Yes, ma'am.
You also may need to report a conviction to your current employer if you're employed at this time. You understand that?
Yes, ma'am.
And then also, if you are convicted of this matter, you also could have impact on travel or immigration status. So you may want to go up to Canada for a visit and they could deny you entry because of this conviction. You understand that?
Yes, ma'am.
Okay. And the reason for the no contest is because of intoxication?
Intoxication and lack of.
Okay. As to added count 2 of malicious destruction of a building 200 or more, but less than 1,000. How do you plead, sir?
No content.
Okay, I have here police report from the Lansing Police Department, case number 2251905-950, from June 29, 2022, at 8:50 p.m. Officers were dispatched and advised that multiple callers called stating that a black male subject wearing a red and blue shirt and dark pants was repeatedly throwing a brick at windows of businesses on Michigan Ave. The accused, identified as Percy Harrison, was subsequently located and arrested for destruction of property. The venue of this was at the City Rescue Mission located at 607 East Michigan Avenue, Lansing, Michigan. Officers indicated in their report that upon arrival, they observed a black male subject seated on the bench in front of 607 East Michigan Ave. The accused was wearing a red shirt with a navy blue long sleeve and dark pants. Officer Caitlin Miller observed that 2 of the front windows of the City Rescue Mission were smashed out, and there was broken glass all over the sidewalk in front of the business. Officer Miller observed a large brick on the sidewalk amongst the broken glass. Officers made contact with a witness by the last name Willman, who advised that she went to her balcony and observed a black male subject throwing a brick at a window of a business on Michigan Ave. Woman advised she watched the accused subject throw the brick at the window 3 to 4 times. Woman advised that between throws, the accused would take a seat on the bench, stand up, and then throw the brick again. The damage to the property indicated in the report says that there was 2 double pane glass windows approximately 6 feet in width and 6 feet in length. City Rescue Mission employee by the name of Kessner advised that each window was valued at approximately $1,200. Any additional factual basis, Mr. Sarts?
No, Your Honor, thank you.
Anything else, Mr. Brodowitz?
Nothing from the people, Your Honor.
The court is satisfied with the factual basis, and the court will accept your no contest plea as to the added count 2 of malicious destruction of a building. I find the reason for the no contest plea to be appropriate, and an entry of guilt will be made by way of no contest plea. Your sentencing is going to be January 4th, 2024 at 9 a.m.
Your Honor, may we do same day sentencing? Just get a sentence today, please.
Any objection from the prosecutor?
Nothing from the people, Your Honor.
I believe Mr. Garrison was in custody this entire time.
Until he was able to bond out.
From June 29th, 2022 to October 2023.
Did you want to make any further allocution?
Thank you, Your Honor. Mr. Harrison is stable now. He has access to mental health care. In custody was largely due to delays with CFP getting him down for treatment. But Your Honor, this time has allowed him to achieve important goals towards stabilizing his mental health. Yeah, he served a full year, Your Honor, so I would respectfully just request that the court order the maximum credit for time served at a county year, and just order the restitution. He has successfully managed to stabilize himself, Your Honor, and he's in a great position moving forward. Thank you.
Do your client want to make a statement?
Like to add anything else? No.
So you said he's now got access to mental health care?
Yes, Your Honor, through CMH.
Okay, you're still engaging with CMH? credit time served and restitution will be ordered in the amount of $2,900. $2,400 is due and owing to the city rescue missions. And then the $500 is owed to the city of Lansing,
It would be the Ingham County Sheriff's Office.
Ingham
Your Honor.
County Sheriff's Office. And we will get those restitution forms in the file. When are you going to begin making payments on that?
Figure something out. So right now I'm currently working on work. So
Trying to find employment? What have you been doing to look for employment?
I've been putting in applications quite a few places.
Okay, so I refer to collections. You need to contact them within 30 days for a payment plan, okay?
Okay.
You have questions at this time? Any additional matters for the record?
Nothing from the people, Your Honor.
And Mr. Radowitz, you're gonna notify Prosecutor Lawton, we're gonna get the Nolly Cross submitted down 55th, correct?
Yes, sir. Yes.
All right, thank you.
You're
Nothing
all
further.
set. Thank you.
Your Honor.
Yes.
This didn't need to be on the record, but just so it gets filed correctly. Do both of these, and even though they're on separate district court files, do they both need to have this file number on them?
Yes.
In order, okay.
We'll go out there. She's going first.
What happens there?
We have Ms. Wheeler.
Ms. Wheeler is present. Okay, and on the record in the matter of the people of the state of Michigan versus Shanique Wheeler, file number 23-03123. Council appearance.
Jeff Radowitz on behalf of the people, Your Honor.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Shanique Wheeler, who is present and standing to my right.
How are you, Ms. Wheeler?
I'm okay.
Okay, and then today was the date and the time that was set for a probable cause conference. The matter is scheduled for preliminary examination December 15th at 9 a.m. After we've already waived the 21 days back on the 27th. We need to address something on the record today.
No, Your Honor. We just wanted it left on for preliminary exam. There was a global offer with her other case.
Okay, but you received the discovery.
I have not received discovery yet in this case,
Okay.
but I was a late appointment just yesterday, so I believe that you should be receiving my appearance soon.
Yep, and we will have discovery out once we receive Ms. Donnelly's appearance here tonight.
Do you have any questions today, ma'am? Okay. Any additional matters for the record today? Do we need another PCC before then? And the reason why I ask that is because we have over a month before the exam, and I don't want it to be the day of the exam for me to find out that you not received restitution. I'm sorry, restitution discovery.
Discovery, yeah. Your Honor, I wouldn't object to one, probably maybe two, in 2 weeks or so.
Okay, let's get a PCC, and then obviously, if you don't need it, Mrs. Donnelly, you just notice my court via email that you don't need it.
November 22nd at 1.
November 22nd at 1. Okay, any additional matters for today's record?
Nothing from the people, Your Honor.
Nothing for defense.
Thank you, you're all set. Okay, and we've not seen Jonathan Carter. I think this is from Harrison's file. No Carter.
I haven't. Nope.
That's unfortunate.
Yeah.
Okay.
He has a caretaker?
That is my understanding.
It's here that the caretakers, he was just arraigned on a previous bench warrant. Caretakers didn't arrive before. Maybe they didn't, maybe they forgot about today. I don't know. Have you been in any contact with him?
No, when I tried to call his phone this morning to make sure he remembered court, his phone is no longer in service.
Well, we have two different numbers in our file. If you want to check to make sure you have the same number we have. We have one that ends in 8180.
That's the one I have.
Oh, okay, sounds good. That was the one they gave us last, so. Okay, well then we'll issue a bench warrant, bond forfeiture.
Thank you, Your Honor. If somehow I do hear from him, I certainly will let the court know and try to arrange this.
Sounds good. Thank you.
Thank you, Your Honor.
Last one, yeah.
Yeah.